of vengeance, but to balance the interests of the community, in this case the membership of the EFF and its voters, against those of the offenders. The duty of the NDC is not to serve any individuals or groups of individuals, but to serve the interests of the EFF itself, and to do so impartially without fear, favor, or prejudice. It would be against the interest of the EFF and its community for any one of them to be subjected to a disciplinary process which is tainted by personal grudges, bias, or prejudged outcomes and the like. For this reason, it is most regrettable that the charged members elected not to challenge their temporary suspensions and not to attend the hearings, as they are entitled to do so in the terms of the applicable rules. By so absenting themselves, they deprive themselves of the perfect opportunity to air grievances internally and perhaps even to prove the validity of their complaints and numerous accusations. This would have gone a long way to disproving their alleged guilt, or even better, in establishing the potential guilt of those whom they fingered as the cause of their own disgruntlement. Given the fact that there is a de facto leadership of the organization as elected in the NPA, in which the charged members participated both in its planning and execution, they would have been better advised to grant that leadership, even temporary recognition, even if their ultimate intention was to demonstrate its lack of legitimacy. To argue otherwise, as they did, leads to the notion that the EFF is currently non-existent. Since the interim structures were dissolved at the NPA by the members and the current leadership is, according to them, illegitimate, then the logical conclusion is that there is no EFF. This flies in the face of any rules of administrative or constitutional law, as well as the laws of simple logic. The failure to attend the disciplinary hearings is also significant for a different reason. It is an act of disassociation from and non-recognition of the organization itself and its constitution and constitutional structures. The Supreme Court of Appeal has described the contractual relationship between a political party and its members as any other voluntary association as follows, I quote, "A political party is a voluntary association founded on the basis of mutual agreement. Like any other voluntary association, the relationship between a political party and its members is a contractual one, the terms of that contract being contained in the constitution of the party." That was the case of Maklowa versus Mahuma in the Supreme Court of Appeal. Accordingly, it seems clear that the enunciation of the Constitution is nothing but an indication of an intention no longer to be bound by the agreement which was concluded at the time of the attainment of membership. It is tantamount to renouncing the membership itself and tendering an indirect resignation. In another court case in the Cape, the sentiment expressed above was articulated as follows, and I quote, "A voluntary association is founded on the basis of mutual agreement which entails an intention to associate and consensus on the essential characteristics and objectives of the association. The constitution of a voluntary association, together with all rules or regulations, if such exist, collectively constitute the agreement entered into by its members," unquote. That was the case of Yiba and others versus African Gospel Church in the Cape Provincial Division in 1999. This principle was reaffirmed more recently by Deputy Chief Justice Museneke and Justice Jafta in the case of Ramakatsa and others versus Mahashule and others in the Constitutional Court in 2013 at paragraph 79 as follows, and I quote, "It is necessary to outline the nature of the legal relationship that arises from membership of the ANC," which was the organization in that case. "At common law, a voluntary association like the ANC is taken to have been created by agreement, as it is not a body established by statute. The ANC constitution, together with the audit guidelines and any other rules, collectively constitute the terms of the agreement entered into by its members. Thus, the relationship between the party and its members is contractual. It is taken to be a unique contract," unquote. Since the members referred us to the court proceedings in justifying their non-attendance, it is also instructive to note that in their court proceedings, they have not, there is no prayer in that application for the holding or reconvening of the NPA. In other words, according to the charge members, the EFF ought to be considered as non-existent forever, or at best until the adjudication, including appeals of the court applications, which may take several years. Their court action is only aimed at nullifying the EFF from existence without replacing it with anything. The prayers contained in their notice of motion in the court action are as follows. 1. Setting aside the election during 2014 of the CCT. 2. Setting aside the election by the CCT of the current members of the War Council. 3. Declaring null and void all decisions taken by the CCT. And 4. Declaring as null and void all decisions purportedly taken by the War Council, including the decision to suspend and institute prosecutors in their proceedings against the applicants. Needless to say, the AFF has opposed this application. As that matter may take years to resolve, it is clear that even if the relief sought by the charge members were to be granted, the correct position is that in the meantime, the EFF does exist and is governed by the instruments adopted by the NPA. To hold otherwise would precipitate a constitutional crisis of unimaginable proportions and may signal the collapse of the fifth democratic parliament. If one follows their logic, then it is difficult to work out why the charged members have recently decided to attend Parliament and continue receiving their parliamentary salaries for the past 4 months or so. They can only attend Parliament if they represent an existing organization called the EFF. That organization can only exist if it has a valid constitution, leadership capable of participating in Parliament, to give mandates, deployments, and to administer discipline. It cannot exist solely for the purposes of providing salaries for the charged members. The stance adopted by the charged members is therefore illogical, internally inconsistent, self-serving, and unsustainable. The NDC was therefore had no option but to continue the disciplinary proceedings in their absence.